Okay, good afternoon, everybody. Good afternoon, everybody. Good afternoon, everybody.
Good afternoon.
Thank you, thank you, thank you. My name is Vincent Sutherland. I am the Executive Director of the Center on Race and Equality in the Law. And I want to welcome all of you to the second in our series on the anatomy of race and inequality in America, done in collaboration and partnership with NYU Law Review. We had our first conversation last Monday at this time. We have another one in a week from Friday on the 15th, focused on criminal justice. But today's conversation is focused on race in an exclusionary democracy. I want to begin by thanking our partners at the Law Review and the center staff and fellows, Denisha Edwards, Sarah Hamilton Zhang, Steve Demarest, and our interns for making this happen. And really want to start off with kind of understanding what our panel is going to be about today. The preamble to the United States Constitution begins with three simple words: we the people. And so this panel is really going to explore what exactly is meant by that particular phrase, specifically how racial identity, racism, xenophobia, and religious intolerance has shaped American democracy and participation in the nation's political life, and the pushes and pulls of efforts to expand and restrict that participation. It's especially fitting that we're having this conversation today, given that tomorrow is election day. So there are local elections going on in New York. Please vote. I think that may go without saying in this audience, but I'll say it again. Please vote. And about a year from national elections. We have with us today a collection of nationally recognized experts, the cream of the crop, as it were, when it comes to this particular space. Joining us by remotely by Zoom is Khalid Boudoun, who's an incredible scholar whose work at the intersection of race and religion has garnered national and international attention. Danielle Lang, seated to the far left, has been one of the leading voices in this space through her work at the Campaign Legal Center. And for me personally, it's a real joy to welcome the other three panelists as well. Myrna Perez and I clerked together in the same courthouse a number of years ago, and I watched her turn out a couple years ago. Watched her turn out victory after victory as a successful voting rights lawyer at the Brennan Center. Atiba Ellis and I clerked for the same judge, and he was in fact my predecessor the year before that, so maybe 3 years ago. And I've watched him watch his career successes mount up as he's become a successful academic. And Ryan Haygood and I worked together for a number of years at the NAACP Legal Defense Fund, where he successfully led the voting rights work of the nation's premier civil rights law firm, and now serves as the executive director of the New Jersey Institute for Social Justice, and has been doing incredible work there on voting, criminal justice, and economic justice in the state of New Jersey and nationwide. So I want to jump into the conversation. I want to encourage our panelists to talk past, across, at one another. It's a real conversation. I also want to save time for all of you to jump in and ask questions as well. We have a lot of ground to cover, but I want to start by kind of grounding us in your own experiences, and want to open up the conversation by just asking you, each of you, to just give us a sense of why it is you chose to work in this particular space. Why political participation? Why democracy? Why voting? What drew you to this work in the first place, and what keeps you motivated to continue doing it? And maybe we can start with Khalid, since he is remote, and then move down the line from Danielle to Atiba.
Yeah, sorry again I couldn't be there with everybody in person, but it's a great pleasure and opportunity to be here with you today. So, what drove me to be in the space? I think of myself as both an academic, but also an advocate of sorts. Currently, in addition to teaching, I'm an equality fellow with Soros, and much of my work is being on the ground in indigent and working class Muslim communities. I've toured the country and have done roughly 25 Know Your Rights trainings around surveillance within Muslim communities, largely, again, indigent Muslim communities. And that work has encompassed looking to mobilize new communities, largely immigrant communities, indigent communities, to be more involved in the voting process. I think one thing that's neglected within the broader Muslim American experience is that a sizable percentage of the community is in fact indigent and working class, and suffers from the same sort of injustices and inequities that any poor or indigent community of color faces.
Great, thank you, Khalid. Danielle.
Well, thank you very much for having me. I suppose I came to law school with a real focus on civil rights and human rights in America, not certain what direction that work would go in. I actually started my public interest career here in New York at the New York Immigration Coalition, where I worked after I went to NYU undergrad. And there I got to see, one, how the power of diverse voices when they come together to assert their rights can really make change, but also the limitations on that within the kind of democratic system that we've set up here in the United States that is not quite the democracy that we dream it to be. And as I continue to work in law school on civil rights and human rights issues, I continue to see that pattern kind of playing itself out, how inspiring it could be when diverse communities in the United States were able to speak for themselves and able to achieve change for themselves, and how they butted up against structures that really didn't allow them to have the same voice as the majority in the United States. And I continue to do a lot of immigrant rights work and civil rights work that kind of reinforce that pattern. And so when I had an opportunity to kind of jump into this space where, as the Supreme Court has said, the right to vote is preservative of all other rights, that it was an opportunity for me to make a difference in a space that I knew would have kind of reverberate across a lot of issues that were near and dear to my heart on civil rights and human rights in America.
Hey, good afternoon. It's great to be here. I'm so excited to be sharing this panel with some fancy people and under my dear friend Vincent's leadership of the center. The quick backstory for me is I learned about this work when I was a high school student in Denver, Colorado. I had this class called The Black Experience. It was a social studies class, and the teacher then used to show us in the sort of black and white videos, this series called Eyes on the Prize, right? And Eyes on the Prize was a video that very powerfully chronicled the civil rights movement, and it featured these folks whose names we would not know, who literally put themselves in harm's way to move our country away from its low practices and closer to its higher ideals. And in these videos, I learned about Thurgood Marshall and the Legal Defense Fund. And that was something that I was sort of in my mind as a high school student, and some years later, I had this incredible opportunity to intern at the Legal Defense Fund. Actually, it was about 20 years ago this year, as it turns out. Although I just turned 25, Vincent. And it was in that summer that I learned about the Freed Frank LDF Fellowship. This is a 4-year fellowship. It still exists. You all should take a look at it. It's a phenomenal fellowship. And it was created with public interest students in mind. So the idea is you spend 2 years at Freed Frank, obviously a law firm here in Manhattan, and the idea is you get some critical legal training. You learn how to litigate. You learn about the architecture of litigation. And then after those 2 years, you go to the Legal Defense Fund and you do LDF's work. And when I got to LDF, I was staffed in the voting rights group. One of my cases was around the issue of restoring voting rights for people with criminal convictions. It was called Hayden versus Pataki. And then after that 4-year fellowship, I spent the next 10 years at the Legal Defense Fund doing, among other things, voting rights work. I'll say quickly, before I left LDF to go to the place where I am now, the New Jersey Institute for Social Justice, the last case I had was a voting rights case which I litigated with Myrna, and it was a Texas photo ID case. We spent 2 cool weeks, I think at least, in the beautiful city of Corpus Christi fighting Texas's effort to implement, at that time, one of the strictest photo ID measures after the census showed that the 90% of the new growth in Texas was fueled by Black and Latino people.
Bienvenidos, welcome. I'm Myrna Perez. I'm basically a grown-ass Mexican kid from Texas, and as such, I have been trying to answer the question of power and what it means to not have it and what does it do to you. I mean, even as a little kid, I didn't understand why some of my cousins lived in trailer parks and some of them had a backyard, and why some of our school books looked shiny and new, and why some of us had teachers that didn't seem to care. I didn't understand why the lack of power meant someone like me getting really, really angry and spending a lot of my life deciding that I was going to be a civil rights lawyer and other of my cousins going to prison. And I think the idea of the vote is really important to me because it is a way of trying to resolve some of the power imbalances that happen in this country. Because if we're doing what we're supposed to, it doesn't matter if you're rich or poor, black or white, or educated or not, your vote counts the same. And in a system where power is so closely correlated to wealth and education and privilege and skin color, I like the idea of the vote to be one of those equalizing functions. And I would explain like the trajectory of my career of trying to find where institutions of power have failed people and tried to go back and try to right that as much as I can. And I think there are a lot of places we can do that. We can do that in the criminal justice field. We can do that in the education field. But we can also do that in the ballot box. And I think in terms of getting your bang for your buck of your investment and getting a good return on that, in making sure that our vote is free, fair, and accessible is one of the most efficient way to use the resources we have in order to try and restore some of that power imbalance.
Well, good afternoon. My name is Atiba Ellis. You know, in thinking about this question, I am thinking about my roots as a poor kid from eastern North Carolina who kind of grew up son of a Methodist minister and in the sort of traditions of the civil rights movement and that kind of dialogue both through the church and through community. And so by the time I got to college and then law school, I had thought to myself, well, first of all, sorry, Dad, I don't want to be a preacher, but maybe I'll be a lawyer, and maybe I'll be a civil rights lawyer. And then, of course, me also being an academic, and I didn't even know I was an academic like 20 years before I became one, which was just right after I clerked with Vincent. I am in my master's program, and I asked my professor about what I could study that could marry these questions of history and law and equality and justice, which my co-panelists have already talked about eloquently. But my way through it was studying a particular case called Harper v. Virginia, which was about the poll tax and the last vestige of the Jim Crow poll tax, at least in its formal form. Of course, we're going to talk the rest of the panel today about how that has reemerged again, I think. But the point is, I did that work as a scholar and then went into practice and ran into it again in the Georgia voter ID cases from like the early 2000s, which I did pro bono. So even for you law students out there, even if you don't see yourself going to a civil rights firm, you can still go to your own firm or your own practice and still litigate these cases. Because I had a beautiful experience doing that. But when I finally answered the call to go to the academy, I dug up that master's thesis, which timed itself with Crawford v. Marion County and the voter ID case from the Supreme Court. And I was off to the races writing about this. And in some ways, I've been rewriting that paper for the last like 15 years.
Nice, great. Thanks to all of you for that really eloquent background and description of kind of your journey to the work you're doing today. And it's pretty clear to me that each of you are really concerned with the most marginalized, the most oppressed communities in our country. And when we think about this notion of race and an exclusionary democracy, Atiba, I want to just turn back to you and ask you to help us kind of think about what that actually means. What are the roots of that exclusion? Who are we excluding from the American democracy? How does that kind of manifest itself?
So in thinking about who are we excluding and how that manifests, I also want to give one other shout out to someone who is here but not here, Derek Bell, most famous visiting professor at NYU, who wrote a seminal book called Race, Racism, and American Law. And he has a chapter in that book called Voting Rights and Democratic Domination. And so I wanted to borrow from Bell's definition here in terms of looking at democratic domination as a problem of the enduring exclusion of African Americans from the political process. And he saw this as having three sort of components. One is being in a numerical minority status, not having enough people to actually just go in and vote, but also lack of economic status, right? The idea that, oftentimes, and we see it today, right? You can buy a defense or you can use money to advocate, but if you don't have that money, there's no incentive for others to agree with you. And then the third thing that he points to is this perpetual ideological desire to discriminate. And he was writing particularly in a black-white paradigm, and that has obviously shaped a lot of American voting rights law. But one of the things when we start thinking forward is how that black-white paradigm is not the only paradigm at play. But to use Bale's terms, these three components sort of have worked together throughout American history to exclude racial minorities from the vote, either directly in the era of slavery, because certainly in a political economy of slavery doesn't make sense if the slaves can vote. And moreover, in thinking about we the people, we can all think through how that we the people, by definition, did not include African Americans, most of whom were in slavery, and even those who were not were often intimidated from or used, whether it be, violence or whether it be sort of social stigma from voting, right? And so that sort of lack of citizenship, which ultimately manifested in Dred Scott v. Sanford, right, where the Supreme Court said all African Americans are, in effect, property who have no rights that a white man need respect, right? So by the time of the Civil War and then Reconstruction, we tried to undo that through the 14th Amendment in terms of defining citizenship, and the 15th Amendment, which guaranteed a right to vote free of racial discrimination. Of course, that idea got betrayed very quickly. Once Reconstruction ended, we saw the rise of Jim Crow, and those factors that Bell talked about, being in the numerical minority, having lack of economic status, and just sheer what I would like to call anti-blackness, worked together, particularly in the Jim Crow South, to exclude people, whether it be by literal racial exclusions, which the Supreme Court, to its credit, struck down. For example, the Grandfather Clause, which had an explicit racial requirement for voting. The Supreme Court said, hey, the 15th Amendment said no racial discrimination in voting, so you can't do that. But then in what was called the Mississippi Plan, there was a whole set of other rules designed to exclude, whether it be through poll taxes or literacy tests or understanding tests, which were in the full discretion of the voting registrar. All these things centered around whether African Americans had enough education to overcome those things, and even if they did, the sheer ability for registrars to say, no, I can make up an excuse for you not to vote. So these things accumulated into just a betrayal of the promise of the 15th Amendment. And so how to solve that problem, we reach this another period of saying, well, we need to fulfill the promise of the 15th Amendment. And so in the era of the 50s and 60s, civil rights advocacy, because certainly civil rights advocacy has been going on, well, frankly, ever since before the Civil War. But in that period of Martin Luther King and LBJ and the passage of the Voting Rights Act, we see Congress finally saying, we're going to make true the promise of the 15th Amendment. And they did so through two ways. One was establishing Section 2 of that act to say that there is a enforceable statutory right to be free from discrimination in voting. And anyone can bring a case anywhere across America. But then there's Section 5, which I'll get back to in a second. But the point of Section 5 was that these states with the history that I just described would have to have their voting rights laws approved either by a federal court or by the U.S. Department of Justice to ensure that minorities were not being discriminated against. So that idea of pre-clearance set the stage for the next 50 years of voting rights litigation, because certainly even after the Voting Rights Act passed, it wasn't to say, well, everything's just fine. But in this spirit of the litigation about being included in the democracy, several things happened to once again betray the promise. One was a case called City of Mobile versus Bolden, which said that 15th Amendment that we're ultimately trying to fulfill, well, the only way you can litigate that is through proof of purposeful discrimination. Discriminatory impact, which is oftentimes the subject of litigation under the Voting Rights Act and under state and federal and local litigation, well, no, that doesn't count. That's not enough to bring a claim under the Constitution. So the only vehicle was the Voting Rights Act. But certainly then we see measures that once again pick on poverty and the intersection of poverty and race as a grounds of exclusion. So those voter ID laws that I alluded to in Crawford v. Marion County were that sort of thing. And then we see the disablement of that Section 5 of the Voting Rights Act in Shelby County v. Holder. And so post-Shelby County, we have another proliferation of laws that hyper-regulate the vote. And that's where we are now.
Great. Thank you, Atiba. Really speaks to this kind of notion of progress, retrenchment, back and forth. And every time you kind of make an advance, there's efforts to undermine that advancement with respect to voting. With that kind of historical framework, Ryan, I want to turn to you and just ask you, how are you seeing the history that Atiba talked about play out in the states that you're working in, most exclusively in New Jersey, when it comes to this
Sure.
notion
So,
of
Thanks,
democracy?
Atiba, for that. I think that was an important historical framing. I do think that, particularly with respect to black people in this country, I think if there's a theme that goes along, if there's a soundtrack that goes along with democracy, it is that democracy for black people and people of color more broadly, and women, has always been a contested exercise, right? So it's marked by periods of expansion, always followed swiftly by periods of contraction, right? So you cannot have on the federal level, you cannot have twice elected a black president and then not have a Donald Trump. You just can't have one without the other. That's always been the theme of our experiment with democracy. And so part of what I was able to do at LDF over time was to begin to think about how you litigate cases on a sort of structural level to bring about some of the power that Myrna spoke about in areas that had been separated from that power. One thing that I came to very early on was the way in which states would use laws that would prevent people with criminal convictions to disproportionately impact people of color. And this is not news to you all. You know that almost every state, with the exception of Maine and Vermont, has some restriction on the way in which people with criminal convictions can vote. And so I've been in New Jersey for 5 years now working on this, among other issues. I just want to lift up our work there as, I think, a case study for what can be done and what is happening across the country more broadly on this issue. New Jersey is an interesting state. You know, I'm originally from Denver. Myrna spent a lot more time in New Jersey. People in New Jersey, I don't know if is anyone in here from New Jersey? Right, I see eyes light up. So, you know, people not in this room, but folks outside the room from New Jersey, when they think about the place, this is a gross generalization. I got no data to support it, just all anecdotal evidence, my own personal experience, which counts. Well, people in New Jersey talk about New Jersey, they get a little bit teary-eyed when they think about the way in which the state is really seen as a beacon for democracy, right? It's where some of the most progressive people live. It's almost all Democrats, so it was interesting because it doesn't always vote that way, but right now New Jersey is overwhelmingly Democratic. It's a Democratic governor, and both branches of the state legislature, overwhelmingly Democrat. There's no Donald Trump to blame. There's no Chris Christie to blame. There's no Republican to blame. If what Democrats want to do in New Jersey is advance the most robust social and racial justice agenda, they can do it. That's sort of the default point. But New Jersey has a really interesting and troubling history with respect to its own involvement in American slavery. New Jersey was the first northern state to restrict voting to white men only in 1844. This is the same year that it restricted voting for people with criminal convictions. New Jersey resisted the Emancipation Proclamation. New Jersey rejected the 13th, 14th, and 15th Amendments. And New Jersey was the last northern state to end slavery. New Jersey was also a state to which some of the southern states looked to circumvent Reconstruction. And that's important because that grounding in slavery informs the reason why New Jersey today has some of the worst racial disparities in the country for Black and Latino people. This is true in every area, in economic justice space. It's true in the criminal justice space. In New Jersey, a Black adult is 12 times more likely to be in prison than a white adult. A Black child is 30 times more likely to be in prison than a white child. 12 to 1, 30 to 1. Highest racial disparities in incarceration in the country, even though we know, data shows, Black and white folks commit most offenses at the same rate. And even where there's a difference in the commission of actual participation in crime, it's not 12 to 1, and I promise you it's not 30 to 1. But the reason those racial disparities in the criminal justice system matter is because New Jersey, like most states, connects its voting system to the criminal justice system. So that New Jersey literally imports racial disparities from the criminal justice system into the political process. So that today in New Jersey, there are about 102,000 people who cannot vote because they have criminal convictions. About half of them are Black, though Black folks make up just 15% of New Jersey's overall population. This is a population larger than our capital city of Trenton. So I have to share this quick story with you. We launched a campaign with a number of folks across New Jersey, a lot of national partners in this effort, through a campaign we're calling 1844 No More, Let Us Vote, right? 1844, again, was the year that New Jersey restricted voting to white men, disqualified people with criminal convictions from voting. We're saying, like, it's time for New Jersey to be 1844 no more. Part of this work has led us to do some really deep research and writing around the history of New Jersey's law. I brought for you a report. It's short. I promise you can read it in 15 minutes on the panel right here. You take it for your reading pleasure. But it has become the heart of a broader campaign to make New Jersey like Maine and Vermont. Maine and Vermont are the only two states in the country that do not restrict voting for people with criminal convictions. They also happen to be among the whitest states. I think they're each at like 95% white, right? Why does that matter? It shouldn't. But if we get honest, it does. And here's how. So as part of our work to encourage New Jersey's elected officials to be as progressive as they see themselves, right? We were meeting with some folks in the state legislature. There were, say, 8 of them. Party doesn't really matter much because, again, I told you, one party could do it if they had the political will to do so. So we're laying out all these arguments that I've shared with you just now. And then I asked them the question, which is, why don't we in New Jersey, we see ourselves as like among the most progressive folks in the country. Florida is making strides in this direction, Virginia, New York, why not New Jersey? So I said, why don't we push ourselves to become more like Maine and Vermont, which do not restrict the right to vote to people with criminal convictions for a number of reasons. One, they recognize that voting is a tool that helps to reduce recidivism, helps to increase public safety, that connects individuals to whole communities. If you want to advance criminal justice purposes, voting actually helps to get you there. If you want to undermine those, then you should withhold the right to vote. But I don't think that's what we want to do. So why not push to make New Jersey more like Maine and Vermont? Now here, it's a tricky question. I anticipated a couple of responses because they typically come back this way. Well, one, Ryan, 48 other states do it the other way. That's a colorable response, no pun intended. The other one is, right, because if we let them vote, we have a sense they'll vote for the other party, right? So the question is out there. Again, the question is, why not push New Jersey to be more like Maine and Vermont? And New Jersey could become the first diverse state to enfranchise people with criminal convictions. I was anticipating one of two responses, but I got the third. And the third was, well, Ryan, straight, the demographics of New Jersey are different. Now this, you all, is actually what animates the popularity of these laws across the country, but I didn't expect it from a progressive lawmaker in New Jersey, right? So then I waited, and then I thanked him for his candor, and I asked him, why do the demographics matter? And then he said, oh, you baited me. You baited me. This was his attempt to try to compose himself to say the next thing, which was, I'm not saying it's race-based, but you actually just said it's race-based. What you said is, if New Jersey's demographics were more like Maine and Vermont's, you'd support it. But because they're different, you don't. And if we get honest, that is really what animates these laws across the country. There is not a fear, as folks say, that they'll do one thing or the other, except that we have a belief that there's something dangerous about voting, and namely that if you empower people, particularly people of color, with the right to vote, they'll use it. And too often, I think, our elected officials are all about the status quo. I'll stop just with the last piece. To Vincent's opening point, tomorrow's an election in New Jersey, right, as is the case here in New York. Every seat in the New Jersey Assembly is up for re-election. There are 80. I haven't received a single mailer about the election. There's been no calls. I see no yard signs. And that's by design, because very often elected officials are keepers of the status quo. And the way they do it is they keep it low when there are elections because they want to preserve their space in the legislature, or whatever the body is. And our push around this is really designed to empower voters, less thinking about elected officials who are in those seats.
Thank you, Ryan, for that incredible contribution about what's happening in New Jersey. I thought it was a progressive state until you just spoke, so I appreciate that. Danielle, I know you're also, of course, in this space, and we've heard about New Jersey, but I'm wondering about how things look in other parts of the country and some of the work that you're doing at the Campaign Legal Center.
Thank you. Just one quick anecdote to underscore what Ryan just said, which is that I was sitting in a car yesterday with my parents who live in New Jersey, and their daughter is a voting rights lawyer, and they turned to each other and said, we have an election this week, right? What's up for election? And the response was a resounding, I have no idea what is even being elected, nonetheless who the candidates were. This is from a pretty politically engaged family. As Ryan was talking, I was thinking a lot about, I don't know if any of you have listened or been reading the 1619 Project, and I won't say it nearly as eloquently as it was said in the podcast, but at the end of the first episode, it wraps up by saying, you know, the United States, kind of like New Jersey, gets all teary-eyed talking about being a beacon of democracy and of democratic values. But they wrapped up the first episode by really hammering home that to the extent that America is living up even a little bit to those values, it is because of hard fights by communities of color in the United States. And that even though the United States was born of exclusion of communities of color, the only reason we can in any way say we live up to the ideals of the country is because of the fight of those that the country was founded on excluding. And I think that in 2019, we're seeing a lot of the same. As far as how we're going to march toward a better democracy in the United States, it's being led once again by communities of color that are fighting the largest voter suppression tool that remains in the American toolbox, which is felony disenfranchisement. We saw that with an extraordinary campaign for Amendment 4 in Florida, led by returning citizens. We're seeing it in New Jersey, and we're seeing it all over the place. So I want to open up with that kind of more hopeful message, because then I'm going to talk about a bunch of things that I find really frustrating with the system that we're living in right now. It is 2019, and there are nearly somewhere between 5 and 6 million people who are kind of de jure excluded from our democracy because of past convictions. In Florida, up until 2018, over 20% of African Americans could not vote. Voting age African Americans were not eligible to vote because of felony disenfranchisement. There are several other states where that continues to be the statistic. Over 20% of the voting age African American population is disenfranchised in 2019 in some states. I think that that's crazy. And I actually think that the problem is even bigger because there are about 5 to 6 million people who are disenfranchised with past convictions, de jure, right? But there's actually close to 23 million people, I believe, in the United States who have past criminal convictions, felony convictions. And as you would suspect, based on the history and kind of that Ryan laid out, those numbers across the country all skew disproportionately in disenfranchising people of color. And that of that 23 million people, a huge percentage of them can vote, right? 18 or 19 million of them can vote. But only if they can figure that out, right? And the systems of felony disenfranchisement in the United States, even where they are more progressive, even when they allow people to get their right to vote back eventually, do so in ways that are enormously confusing. In Arizona, for example, the rule is that if you only have one conviction, then you can vote as soon as you finish your sentence, which includes fines, but not payment of restitution and fees and costs. So if you can figure all that out, and then you can restore your right to vote. If you have more than one conviction, then you need to fill out this pro se packet that's about 25 pages long and submit it to a court and wait for the court to issue an order to say that you have your right to vote restored. Even if the convictions were all bundled together in one set of conviction, in one date, one kind of incident that led to your convictions. In Nevada, until last year, whether or not you could vote depended on what category of conviction you have, A, B, or whatnot, whether or not your category B felony involved substantial bodily harm, whether or not you had honorable or dishonorable discharge, how many convictions you had, whether or not they were involved in the same incident, etc. There was nobody in Nevada who knew if they had their rights restored. I promise you, we were working on the ground with organizers in communities of returning citizens. Everyone just said they couldn't vote. Not true, but given that system, how could you expect any other result? And I could give you 20 more examples of that. There are a number of states where, oh yeah, you can get your right restored, but you have to go over here and get this piece of paper signed by this person and then take it to this other place and get it signed by another person. And then when you bring it back, you have to bring it to the commission, and then they'll send it up to the Secretary of State. And then after the Secretary of State sends it back down to the election office, then maybe you can vote. And it turns out also that states are remarkably good at getting lists of people with felony convictions that they should kick off the rolls, and remarkably bad at getting lists of people who've had their rights restored and so shouldn't be kicked off the rolls. And so what you find is that people with convictions who've had their voting rights restored go to register to vote and get a letter back that says, no, you have a felony conviction, you can't vote. Prove to us that you've had your rights restored, because we can't manage to get those records ourselves. And some even actually have an affirmative requirement that you provide that documentation in the first instance. And so the rules are so extraordinarily complicated that you have to imagine that the number of people being disenfranchised by this system, the number of people of color being disenfranchised by this system, isn't anywhere near 5 million. It's way larger. And there is a lot of work to do there, a lot of work to do in very progressive states, a lot of work to do here in New York on that issue, which I think is something that we'll talk about a little bit later. So there's all this really interesting work to be done on the nitty-gritty. In Iowa, for example, it's been proven that they keep getting lists of people who were charged with felonies and then never convicted of felonies, and those people are getting removed from their rolls. It's not getting fixed, right? There's obviously work being done on that issue, and we're working very hard at it. But there are dozens of examples of this across the country, and so much work to be done. So CLC is really trying to focus on that, not just that de jure number of people who've actually cannot vote under the law, but also those people who are, as a practical matter, being excluded. And we have launched a tool called restoreyourvote.org, where people with convictions or advocates and community leaders that are working with people with convictions can put in the state that they want to vote in, answer, oh, have you had a felony conviction? Yes. Then, like, are you done with parole? Are you done with probation? Answer questions to get plain English answers about whether or not they can or cannot vote, and what steps, if any, they need to take, and make those steps as simple as possible. By getting that information out into communities, we can empower communities to not allow this kind of de facto disenfranchisement to happen, and to kind of infect the entire community, because we know that where there are whole communities that feel disenfranchised, it's not just the people who are actually disenfranchised who don't vote, but it's often their communities. If you don't see your parents voting, the likelihood of you voting is much lower. And so it reverberates out in our communities of color. And the other thing is, once people with convictions start asserting their rights, start kind of demanding rights restoration, where it's legally permissible, we can surface all of these administrative problems and litigate and advocate to get them fixed, to get the lists fixed, to make sure that states, if they're going to have these laws, at least are administering them in a way that is remotely fair. And then the other issue I'll raise, which I'm sure is one that you all have seen in the news recently, is the question of felony disenfranchisement and how it gets even further entangled with economic power, as we were talking about earlier, when the requirement is that you pay off your legal financial obligations in order to vote. There are, I think, 8 states that have explicit requirements that you pay off your legal financial obligations in order to restore your vote. They differ slightly in different states. And Alabama is one of those states. Alabama has a system that until very recently actually looked a lot like the Jim Crow system of giving registrars all the ambiguity they need to disenfranchise only people of color. It disenfranchised people convicted of felonies, quote, involving moral turpitude, and then just never defined what that meant. And left it to registrars to decide, oh, is your felony involving moral turpitude or not? Let me decide. And then after CLC filed a lawsuit in 2016 challenging that system, the legislature finally passed a bill that kind of defined that term, and in doing so, enfranchised tens of thousands of people. Note, they didn't actually communicate that to those tens of thousands of people, which returns me to my prior point. But Alabama is also a state where you can get your rights restored through an application process, and it's mandatory if you meet all the qualifications, but one of them is that you pay off all your legal financial obligations. I have a client who owes over $40,000 for her single felony conviction that didn't even merit a prison time. The judge considered it to be, an offense that did not merit prison time, and yet she owes over $40,000. She'll never be able to vote under that system, ever. She works a minimum wage job. So we have brought a challenge in 2016 saying that this is a modern day poll tax. It violates Section 2 of the Voting Rights Act because of its discriminatory impact on people of color above and beyond what the discriminatory impacts of felony disenfranchisement overall. And it violates the 14th and 24th Amendments for imposing essentially a wealth restriction on access to the right to vote, albeit for a smaller community of people. These claims are going to bubble up to the surface very quickly. As I think Myrna's going to speak about, in Florida, the same issue is being litigated. It is extraordinarily important because this is the barrier, right, for a lot of states that have rights restoration schemes. The thing that makes people serve their time on parole and probation, but they do not finish paying their fines and fees because we saddle folks with way more debt than they could possibly afford to pay in many lifetimes. And we'll see this reverberate out. It's not just about kind of explicit restrictions, but a lot of times you end up on what they call pay-only probation, which means that the only reason you're still on probation is because you still have money to pay. So there are implicit ways in which even more states have these types of restrictions. So it's something worth keeping an eye on.
Thank you so much, Danielle. And maybe, Myrna, if you can talk a little bit about kind of the work that you're doing at the Brennan Center and specifically focusing on some issues that Danielle raised with respect to Florida and kind of a couple other states that you're engaged in as well, that'd be great.
Okay, well, I think I'm going to continue the discussion largely focused on felony disenfranchisement. And I do want to talk about Florida as a case study because I think it is really revealing for law students 3 big themes. 1, there's a demand and a need for persistence if you're going to be doing this work. 2, you need to be able to take a lot of losses on the chin because you lose a lot of the times. And 3, even when you win, there's going to be pushback. I was struck by Danielle's 2016 state. The first lawsuit I worked at the Brennan Center was on Alabama's moral turpitude case. The first time I ever mooted Ryan was him getting ready for a felony disenfranchisement case. I'm glad that this is an issue that has gotten a lot of public consciousness now, but this has been, for some of us on the, a near 15-year fight and even started even prior to that. So let's talk about Florida. Prior to 2018, Florida was the worst of the worst in that it didn't matter what you did. It didn't matter how long ago you did it. It didn't matter how old you were when you did it. If you had a felony conviction, it was a wrap. You did not get your right to vote back unless the government specifically pardoned you. And things like messing with lobster traps were felonies. And Florida has a extraordinarily pernicious history about this. The Brennan Center first got involved in Florida because we looked at it from New York and was like, this is really messed up. We need to file a lawsuit. We went through the constitutional history and discovered that right after the 13th, 14th, and 15th Amendment, Florida changed its constitution to do 2 very important things. First, it disenfranchised people broadly because of felony convictions, and then it expanded the kinds of crimes that made you get a felony conviction. And that's not new. We've also seen examples of that in Alabama and in Mississippi. Ryan's work used to do a lot of work on how Mississippi expanded that. So we filed a lawsuit, a bunch of egghead lawyers from NYU brought in, all the experts. We lost on a 2-1. It was a great case. We lost on a 2-1, and basically it was because the panel decided that even though it is indisputable and will concede that it was discriminatory when they first passed this Constitution, they had to reissue it, about 30 years ago, and there was no discrimination then. So it was like the same policy, but because they didn't have this racial animus when they reauthorized it, there wasn't a problem, and therefore we couldn't use the racially discriminatory history of it to strike the law down. So that stunk. That was really bad. It was very demoralizing. So then we started doing a push to try and get the executive, the governors, to try and use his clemency power. And I use the word his because it's always dudes, but like his clemency power to try and pardon people. We did okay. We got some serious progress. And then next election, a new governor came in and changed the policy. So it was even worse than what it had been under the Bush administration in Florida. And at that point, some impacted people who the Brennan Center and LDF and ACLU and others had been working with for the better part of a decade had just said, you know what, this is enough. The people are with us. The legislators are not helping. We're going to take this to the people. And it was a very up and down campaign. Like, if you look at it, there are certain parts of time where it was like, ooh, this is not going to go very well, and then a big infusion of cash went, and then it went better. And the Brennan Center was part of the original drafting team for the legislation. And we had to look at a lot of polls and do a lot of focus groups to figure out where people were and what we could move people on, like what we could get people if we talked to them in the right way, if they were hit up enough with the right kind of people and the right kind of messengers, where we could move people. So we got enough signatures, went to the ballot, and in one of the best nights of my life, we won. We won. And the part that was so beautiful for me was that on that day, I'm sorry, I'm getting, on that day, Floridians went to the ballot to cast a vote to allow their friends and neighbors who couldn't vote to have the right to vote. They got out of their own head. They got out of thinking about themselves. They got out of caring about like what it was going to do to the politics or not politics. Like people figured out that that was the right thing to do. And that if we are a country of second chances, which we believe we are, and if we are a country that thinks that people can be redeemed, it doesn't make sense to permanently block somebody. So, great day. Everybody's really excited. Everybody's walking around in a daze. We're really, really happy. We're trying to get as many people on the rolls as we can. And then we learned a couple of interesting things. One, people were not registering as many as we expected. People were registering, to be very clear, but I've got a statistician that was looking at who had just gotten released from prison, or who had spent some time in prison in the last 20 years, who was out, and who was registering to vote. And while the numbers were laudable and way bigger than in other times, it wasn't as many as we'd hoped. And then the legislature started monkeying around and passed this really regressive law that basically closed a bunch of opportunities for folks to be able to get their right to vote back. So it said, you know, if you have a civil judgment, if you have a restitution or a court fee that gets converted to a civil judgment, no longer a criminal judgment, by operation of law, we're going to say that that is something that gets in your way. We're going to say by operation of law, if you own any fees or fines or restitutions, you are not going to be able to be eligible for this. And that's really important to realize, because things like probation and parole and who pays what and whether or not you as a court user are required to pay a user fee, those are all creations of law. Florida uses criminal defendants to fund their criminal justice system in a way that is out of proportion from what other places do. And it's understandable. These people can't return, like they can't hit back at the ballot box saying we want some of those laws changed. So the really rotten thing that these legislatures did is they paired it with an election security bill. I'm sure that most of you had heard that there was a lot of threats of Russian cyber criminals trying to mess with our election system. So in the same legislation where folks were trying to deal with fixing early voting issues and trying to get election security money, they passed this bill basically trying to put people in a windowless box about what you voted for and whether or not people would be out to support it. So the legislation was passed. Brennan Center, ACLU, Southern Poverty Law Center, CLC, Legal Defense Fund. Am I missing anybody? Yeah, we all filed in. There's a mess of lawyers. It's 50 people conference call. It's a giant circus. But we're pushing back. We had a preliminary injunction hearing in which we got what I would call the losingest winning decision that I have ever got, where it was a very narrow decision, one that hopefully will survive scrutiny from the 11th Circuit. But I think pregnant in that are, again, those three lessons. If you're going to do social justice work, you have to be persistent. If you're going to do social justice work, you have to be prepared to lose a lot, and you need to be able to get up the next day and do it. And even when you win, third thing, you have to be ready for the pushback, because the pushback is going to come, and you need to have a plan for that. Fortunately, we knew this was likely to come, and so we all got our march of armies ready. But as I tell folks, you know, again, the win wasn't how many people we got registered. It's the fact that we were able to reach people and to say that, you know, someone who has a criminal conviction in their past is not someone that you should write off or like ostracize from our community for the rest of their natural life. There are ways, there are opportunities that it's good for all of us to bring them in. And that is something that we can build off of irrespective of how we do in the court. And that is something that we're going to continue to be doing organizing around.
Great. Thank you so much, Mirna, for that wonderful description of your work and also kind of this long-term fight that you're having in Florida. And of course, felon disenfranchisement is not the only kind of dimension of exclusion that we're kind of cognizant of when we think about the American democracy. Khalid, you're a scholar who studies kind of the intersection of race and religion, and of course, the religious divide, I think, has always been explicit, and I think has become even more so under the current administration. I'm wondering, what does that kind of mean for us here when we think about this notion of an exclusionary democracy, and then kind of backing out from America? What does that mean in a global sense? If you can give us a sense of that as well.
Yeah, so much of my work addresses how religion is focal to how race and racialization functions. We can talk about the earliest stages of American history from 1790 to 1952, when whiteness was a prerequisite for naturalized citizenship. Race at that juncture did not only mean one's phenotype, one's physical complexion. It also meant which faith that individual adhered to. And in my work, I track how Muslim identity, individuals who identified as Muslims were denied whiteness and also denied citizenship as a consequence of that racialization. So those roots are, very salient when we think about how religion is also racialized today in the United States. We see it with not only the rhetoric of the Trump administration, but also the policies of the Trump administration, most starkly through the Muslim ban. That, in my work, I talk about how the Muslim ban was not only immigration policy, it was also an indictment of the 8 million Muslim Americans living stateside, living in the country today. So religion is focal. And in addition to drawing distinctions along religious lines on the domestic level, it's critical to see how that's also functioning on a global level. What's occurring with Trump is very much a global phenomenon. My next book is examining how Islamophobia is being exported into different nation states. We see, for instance, how it's unfolding in places like India, how it's unfolding in places like China, where the very tactics of the Trump administration to effectively cast not only Muslims, but other religious minority groups at large. I think Islam is sort of exceptionalized in terms of being a antithetical religious group or a demographic from Americans. But we see how what's happening here stateside is unfolding very virulently in places like India and in China. In China, for instance, you have internment camps where up to 2 to 3 million Uyghur Muslims are being imprisoned. In India, you have strong men like Modi, emulating what Trump is doing to effectively cast Muslims in that country. And I believe there's up to 300 million Indian Muslims, if not more, being cast as not only second-class citizens or third-class citizens who are denied a whole host of rights, including the right to vote, but are being cast as non-citizens. So we can look at the work, for instance, of Linda Bosniak, law scholar, who talks about citizenship being stratified on substantive levels, how in the United States, but also in India and in China, religious identity being used as both a proxy for racial identity, but also as a distinct form of othering individuals is used to cast entire groups of people as individuals who are non-citizens and can't engage in the very processes of citizenship, fundamental of which, is voting.
Great. Thank you, Khalid. So I have a few more questions for you all. We don't have that much time, but I want to ask them anyways. I'll ask mine, and I'll open up to the audience. So we know that America is becoming a much more racially diverse place, and by 2050, people of color will be a majority in this country. And so I'm wondering, what does that shift mean for the fights of the future? What do you all see kind of on the horizon in terms of what we're going to be worried about in 15, 20 years that we're not really as concerned about right now when it comes to this notion of the American democracy?
I think we are a long way away from figuring out how we translate numbers to political influence. And I think that is because of the legacy of power and how it has been implemented. I think it is because of information gaps, and frankly, I think it's a frustration with the system so that folks don't want to buy in. I mean, when you think about it, the direct benefit you get from voting is extraordinarily attenuated, but you're the one that has to like stand in line waiting your turn to be able to cast a ballot. So I think one of our big challenges is making sure that folks are able to see the connection between numbers and political influence. I also think we're going to see the increase in voter suppression because people that have power do not want to lose theirs. And just like there's not going to be a silver bullet, like if you asked me what are the 3 things we can do to make this better, I'd have my 3 answers, but voter suppression, we didn't get into this place because of one policy. We got into this place because there were a bunch of policies like compounding each other. And so we're going to have to go out in a bunch of different realms and fight a bunch of different fights because each of these suppression methods is about shaving certain percentages off, and each of the progressive methods are about putting percentages back on. So this is going to be like a struggle that we're going to have to be living out until we are able to get to a place where folks don't view loss of status in the way that they do and where we're able to convince people that there's enough in this country for all of us.
Yeah, and I mean, the voter suppression, I'm sorry,
go
I'll be
ahead.
quick. Like, the voter suppression game is a game of whack-a-mole, right? I mean, that is, in essence, a lot of what we're doing is whack-a-mole. And part of the reason it's so easy for voter suppression to be whack-a-mole is because we have a society that is structured in ways that has systematic differences in the communities of color that can be taken advantage of and exploited, right? You know, economic differences, the ways in which we're segregated in neighborhoods so that you can put less machines at the precincts in communities of color. The fact that our communities are so segregated and have very different experiences in the United States means that you can find a bunch of different ways to structure the voting rules that will affect some communities a great deal than others. One thing that we've been seeing recently is kind of a direct attack on naturalized citizens because there are people who are very afraid of the changing complexion of American democracy. We got Texas devised this brilliant system where it was going to find all the non-citizens on the rolls by looking at DMV data of people who had been non-citizens when they got driver's licenses that were on the registration rolls, and announced there's 95,000 non-citizens on the voter registration rolls, and they're voting. This is an endemic, epidemic, and it doesn't take a genius to figure out that tens of thousands of people naturalize in Texas every year. Texas driver's licenses last for 6 years. So these were all just naturalized citizens that were exercising their lawful right to vote. In fact, exactly what we would expect of naturalized citizens. We'd show up at naturalization ceremonies to register people, and these are the folks that were being targeted. So I think we're going to see a lot of these types of mechanisms, but they are, but I agree with Myrna that the bigger project is going to be that those mechanisms cannot be successful if we can convince these communities to connect the dots and make sure that we empower them, because for so many decades the system has been, understandably has felt rigged.
So I want to add 2 thoughts to that. One is that nature of the rigged system. It's the continuing theme in American history, and I would say that we're already facing the 2040 problem, right? I think that there is heightened racial anxiety present today because we're not the only ones who can see, 20 years down the road, and that this is already, just read the New York Times expose yesterday on Trump's tweets as laying out a lot of that evidence, I think, now. We could do a whole other hour and a half on that. But I think the flip side of this is by 2040, we will be a country that is a majority of minorities, right? And to defy that sort of claim I made in the very beginning about the black-white paradigm, it is going to be a far more diverse country with varying interests. And so one of the challenges going forward, which connects to connecting the numbers to influence, is to coalition building, I think, right? And sort of building a recognition of all of us being involved together. But the politics that we've been talking about stymie that understanding.
I would add one quick thing. I saw the time, 10 minutes, about 5 minutes ago. But I just turned 45, and this thread of our conversation reminds me of the era in which I came of age. It was when this pioneering rap group called Public Enemy had come on the scene in 1989. Folks, you all, if you don't know, you should pretend like this is New York. They're from New York, right?
Yeah, you better.
But they had this classic CD year. Vincent is also a very popular DJ, so he's familiar with Public Enemy's work, but there's a very popular CD in 1989 called Fear of a Black Planet, right? And in 1989, Public Enemy's CD really foreshadowed a moment in which people of color, to Atiba's point, will become the majority, and there would be this corresponding fear that would attach to the browning of America. And I think we're in that moment. We have seen this. Barack Obama, right, he is running at the height of this fear. And if you look at how he won, it's fascinating. People think that was kind of a Michael Jackson, We Are the World moment where folks joined hands, right? And together they voted in a black president. But voting was very polarized racially. Both times when he ran, he did incredibly poorly in the American South. He gets like 10% of the white vote in Alabama. He gets 11% of the white vote in Mississippi, 14% of the white vote in Louisiana. He only wins because of a coalition of voters, young people, women, older voters, black people, black women especially, outside the American South and inside the American South. And so I think about the way in which the other theme for democracy for people of color and women has also been that precisely when people of color are poised to use their political influence is when there's an intense assault on their ability to do so, even before they recognize, to Myrna's point, how powerful they can be. It's almost like when there's an opportunity to even conceive of a powerful base through voting is when the assault gets even more intense. And so I just want to say, I've been doing this work on the state level for a long time now, 5 years. It's a long time in this work. After having done it for about 12 years nationally, I think very often the national perspective is all national. And there's a lot of focus appropriately on Donald Trump, right? Folks know what the federal challenge is. But in a lot of ways, Donald Trump has become a distraction because people of color were suffering before there was a Donald Trump, even during and before President Barack Obama. And I think the theme of this moment is that when social justice has happened, when change has happened, it's always, always, always happened from the ground up in our communities, not Washington, D.C. down. So that even in difficult federal moments, difficult national moments like now, there's incredible power to be harnessed at the state level. Florida is a great example of this. Iowa is a great example of this. This happens across the country, and I think that should be the fourth, maybe the 2B point to Myrna's presentation, which is that no matter how difficult the national moment, there's power to be organized, power to be harnessed. Think of Public Enemy 30 years ago from the ground up.
Fantastic. So let's open up. We have a couple minutes left. Open up for questions from the audience. I'll take a couple in a row, and then maybe folks can just choose which one they want to answer. And if folks don't have questions, I have a couple I can ask too. Yes. Okay, that's one question. And anybody else have another question? Yes. Joe, go ahead.
Before I came to law school, I worked in Louisiana for 3 years at a group that was organizing and engaging people to register to vote. We had some really amazing support from national legal organizations, but it really made me sort of have a clarification that as attorneys and as representatives of organizations with immense power and influence and legal weight behind you, how do you conceptualize yourself as part of the movement, exactly what you were talking about, Mr. Hargett, as necessarily built from the ground up, as someone coming in and working in collaboration with organizations and maintaining the relationships between the organizers who are doing a lot of the work and that are necessary to really realize the ambitions of changing voting rights laws to actually be able to increase the participation of the vote. I'd love to hear what your conception is and how you take that community to motivate you on an everyday basis.
Okay, so if folks can choose whichever question.
No, right?
What's that?
I think
Oh, one is one. Yes. True.
So, you all made a great point about coalition among racial minorities, and of course, race is a construct, and who gets to be part of whiteness has evolved over time. As people look toward creating like broader and more diverse coalitions, what would you all recommend or think would be helpful to make it such that racial groups who are not Black do not choose to distance themselves from Black communities and invest in a closer proximity to whiteness, rather than, I suppose, like actually taking this to dismantle broader racial castes?
Okay. So you got about 3 minutes to answer those questions. 'Cause I gotta go teach. So go ahead. Let's do it.
I'll start with him first.
Khalid, any thoughts on any of the questions, or could you hear them all?
I couldn't hear the questions, unfortunately.
Okay.
Yep.
All right. Well, we'll move on. One was about ensuring that vulnerable elderly folks are able to be connected to the resources they need in order to be able to exercise their franchise. One was about connecting local organizing efforts to national organizing efforts, and the other was about ensuring that your coalition building is racially diverse, and how do you ensure that that actually happens. Why don't we just try and, Brian or Myrna or Atiba or Danielle, if you have any thoughts on any of those
I'll
things.
take the second question because I appreciate that one. I'll share this with you. It's a bit of a challenge, and I'll share a personal reflection quickly about my own sort of evolution in this area. So Myrna mentioned that when I was a junior lawyer, I had a case in Alabama that I worked on with a pretty famed local attorney there, and we won. Our clients were one of our clients was the Alabama State Conference NAACP. So we win. I got to confess, I'm feeling myself having won this case. We hosted dinner for our clients because we've just blessed them with this victory. This whole thing. I'm, again, feeling myself. That's important for you to know. And I was a young attorney. All right, I just turned 45, but at the time I was a young attorney. And so I'm feeling myself. That's important to know. We host this dinner, and I'm telling them about, the strategy, what we've done, how this opened up some rights, what those rights are. And an older gentleman in the back raises his hand, and he begins, once I say, yes, sir, he says, hey, young fella, and I know a lesson is coming, right? He said, how did you decide to focus on that issue? Because you got resources, you had some time to focus. Like, how did you land there? And he says, because if you had asked me or perhaps us, we would have asked you to focus on this other issue. And what I realized was, to your question, I had done very little consultation with folks in the community. I just sort of saw my role as like, at a national organization, we could do good work on behalf of communities, open up rights, and then tell them about those rights, and they should be, right, they should be like thankful that we did that, and then use them. And so I'm just being honest, right? So what I learned is it was a better move to first understand what kind of work was happening in a community, and then how we could partner with the existing effort to think about advancing that work in a way that they thought made sense, and that when we left, would allow them to keep doing that work and more of it. So I think that's an orientation that I had to learn, I think it exposes a difficult relationship between the national groups and some local groups, and different national groups do that better or worse. But in my own evolution, it's something that I had to learn, and I learned that lesson very early on, and it's something that guides my work today.
So unfortunately, I think we're, oh, go ahead, Danielle, yeah.
I just wanted to speak, I guess maybe I'll just answer the two other questions in the briefest form possible, which is that there is a overlap between disability and race and age that is endemic in our voting system, and it has to change. And there's the National Disability Rights Center is doing extraordinary work on this, but there needs to be a lot more focus, and I think that the voting rights community as a whole needs to do a better job of recognizing that intersection and protecting disabled persons' access to the vote. But and then I don't have an answer to how we're going to fix the coalition problem, but I want to add a complication just because I've spent a lot of time today working on it, which is that I'm bringing a coalition claim on a Section 2 coalition claim in Virginia Beach. And the argument that the defendants have made is, oh no, you can't argue that this coalition of minorities that have been historically disenfranchised against can assert their rights together to get a majority minority district. No, we have to look at them all separately. And since they separately can't make up a district, they should lose. So I think we have to be careful about the ways in which, folks are cognizant of the ways to split folks apart who share a history of discrimination and exclusion in this country. Be very cognizant that folks are aware of how to exploit that and try to push back against it.
Last word. As to this third question, because I think I will put one point out there. The question that you pose sounds to me like how other minority groups can buy into myths of anti-blackness, right? And think about Ibram X. Kendi's book, and other work about that. And so I think naming that and working to that as a different level of consciousness building is also important to this work.
Myrna, you want the last word. You about the, yeah.
I'll just say that I think folks who are trying to keep power for themselves do not care what color you are except for you're not being there. So we need to make it a point of not falling into things like the black-white paradigm. It's not simply another view, it is inadequate. The photo ID law that Ryan and I fought against, or Danielle too fought against in Texas was not because there was a growing African-American population, it was because there was a growing Latino population. And so we need to make sure that our jurisprudence and the way of working with each other and the way of talking publicly is as inclusive and participatory as we pretend that we want it to be. We need to all be right when we're doing that.
Fantastic. Join me in thanking our phenomenal panel. And thanks to all of you for coming out. I hope to see you all next Friday for a panel on criminal justice in this particular space. Thanks again, everybody.